Hey folks, welcome to today's Law of Self-Defense show. I am, of course, attorney Andrew Branca for Law of Self-Defense. Thank you very much. Today, we are going to be doing a reading of U.S. v. Rahimi. Rahimi was someone who was convicted of being in unlawful possession of a gun because he was under a domestic restraining order at the time. And there's a federal law that exists that says if you're under a domestic restraining order, it's unlawful for you to be in possession of a gun. He challenged his conviction on the grounds that that statute was unconstitutional, a violation of his Second Amendment rights. At trial, he was convicted. He appealed his conviction to the Fifth Circuit appellate courts, federal appellate courts, and they interpreted that federal statute and found it to be constitutional, not an infringement of the Second Amendment, and they affirmed his conviction. But then the U.S. Supreme Court decided Bruin, and Bruin set out a new standard for the evaluation of laws that purportedly violate the Second Amendment. So it went back to the Fifth Circuit, another three-judge panel heard Rahimi's appeal, now under the framework of Bruin, and unanimously ruled that that federal provision holding that it's unlawful for someone to be in possession of a gun while they're under a domestic restraining order is an unconstitutional infringement of the Second Amendment. I'm reading Rahimi now. The Fifth Circuit appellate decision that reversed Rahimi's conviction found that statute unconstitutional under Bruin because it is being appealed to the U.S. Supreme Court by the government and various supporters of gun control. And friends of Law of Self-Defense have been submitting amici briefs in support of this Fifth Circuit opinion. So it will be argued at the Supreme Court. We'll see it there in the future. In the meantime, what we have is this Fifth Circuit opinion. With that, I'll pull it up and we will jump in to this reading. Let's see if I can do it like this and still manage to read the decision. Hey folks, before we jump into United States v. Rahimi, my reading of it, and I'm sure you noticed the change in shirt and tie, a brief interruption, because after I recorded this show, I became concerned that I hadn't adequately addressed a common misconception about this decision that I'm sure will be propagandized by the gun control fascists. And that is that there are really two grounds under which one may find themselves under current law, stripped of their Second Amendment rights while under a protective order. And the Fifth Amendment is finding only one of those unconstitutional. So the two ways are there's an actual finding of dangerousness on the part of the person restrained by the protective order. Nobody is challenging that reason for, at least temporarily, during the period of the restraining order, stripping that person of their Second Amendment privileges. Everybody agrees that it's always been permissible in American history and tradition to deny arms to people who are demonstrably dangerous. That's not the problem with Rahimi. And Rahimi was never found to be dangerous. There are some surrounding facts that kind of suggest the dangerousness, but in the issuing of this court order in question here, there was no finding of dangerousness. So that's not the ground on which people are questioning whether Second Amendment privileges should be stripped. Everyone agrees. That's fine. If someone's dangerous, they ought not have guns. The difficulty is the second ground for stripping someone of their Second Amendment privileges under a court order of protection, which is a civil order, not a criminal finding. It's a civil order. And that is as part of informing the person being restrained by the court order that they are not in the future to cause some harm. That's not a finding of dangerousness. That's just cautioning the person against acting in a dangerous manner in the future, which they may never do, may never have thought of doing. It's completely speculative. That is the ground on which Rahimi here was stripped of his Second Amendment rights. That was the basis for the court order of protection. That is what Second Amendment advocates are arguing should not be sufficient to strip someone who has not been found to be dangerous by any court in any criminal proceeding. They're merely being cautioned not to be dangerous in the future, that that person should not be stripped of their Second Amendment rights in the absence of a showing of dangerousness. So this is not about giving access to guns back to domestic abusers. If someone can be shown to be violent in a criminal context, or I suppose even by a civil court, then that would be sufficient to at least temporarily strip them of their Second Amendment rights. But you would need that demonstration that they are dangerous before the removal of the rights could constitutionally occur. Absent that, they have all their normal Second Amendment privileges, even if they are going through a divorce, even if a pro forma protective order has been sought and received from a family court. All right, folks, I wanted to clarify that. This is not about giving guns to domestic abusers. They're not in the mix here. That's not at all what we're talking about. All right, with that out of the way, let's go ahead and proceed with the show. So here we have the decision, United States Court of Appeals for the Fifth Circuit. This was filed March 2nd, 2023. The three-judge panel, Corey Wilson, Judge Jones, and Judge Ho. The decision was written by Circuit Judge Wilson, and there was a concurrence, in addition, written by one of the other judges. We'll read that as well. So diving right in. Our prior panel opinion, United States v. Rahimi, is withdrawn, and the following opinion is substituted therefore. They had a decision that was the same on the merits. They had published a month prior to this, exactly a month, and they're just replacing that version with this version is all they're saying there. This is the final version. The question presented in this case is not whether prohibiting the possession of firearms by someone subject to a domestic violence restraining order is a laudable public policy. The question is whether 18 U.S.C. 922 G8, a specific statute that does so, is constitutional under the Second Amendment of the United States Constitution. In the light of New York State Rifle and Pistol Association, Inc. v. Bruin, U.S. Supreme Court 2022, it is not. Zaki Rahimi levies a facial challenge to Section 922 G8. The district court and a prior panel upheld the statute, applying this court's pre-Bruin precedent. Rahimi filed a petition for rehearing en banc. While that petition was pending, the Supreme Court decided Bruin. The prior panel withdrew its opinion and requested supplemental briefing on the impact of that case, Bruin, on this one. Considering the issue afresh, we conclude that Bruin requires us to reevaluate our Second Amendment jurisprudence and that under Bruin, Section 922 G8 fails to pass constitutional muster. We therefore reverse the district court's ruling to the contrary and vacate Rahimi's conviction. Subsection 1. Between December 2020 and January 2021, Rahimi was involved in 5 shootings in and around Arlington, Texas. On December 4th, after selling narcotics to an individual, he fired multiple shots into that individual's residence. The following day, Rahimi was involved in a car accident. He exited his vehicle, shot at the other driver, and fled the scene. He returned to the scene in a different vehicle and shot at the other driver's car. On December 22nd, Rahimi shot at a constable's vehicle. On January 7th, Rahimi fired multiple shots in the air after his friend's credit card was declined at a Whataburger restaurant. Officers in the Arlington Police Department identified Rahimi as a suspect in the shootings and obtained a warrant to search his home. Officers executed the warrant and found a rifle and a pistol. Rahimi admitted that he possessed the firearms. He also admitted that he was subject to an agreed civil protection order entered February 5th, 2020 by a Tarrant County State District Court after Rahimi's alleged assault of his ex-girlfriend. The protective order prohibited Rahimi from, inter alia, committing family violence, going to or within 200 yards of the residence or place of employment of his ex-girlfriend, and engaging in conduct including following the person that is reasonably likely to harass, annoy, alarm, abuse, torment, or embarrass either his ex-girlfriend or a member of her family or household. The order also expressly prohibited Rahimi from possessing a firearm. A federal grand jury indicted Rahimi for possessing a firearm while under a domestic violence restraining order in violation of 18 U.S.C. 922 G.H., which provides, "It shall be unlawful for any person who is subject to a court order that A, was issued after a hearing of which such person received actual notice and at which such person had an opportunity to participate, B, restrain such person from harassing, stalking, or threatening an intimate partner of such person, or child of such intimate partner or person, or engaging in other conduct that would place an intimate partner in reasonable fear of bodily injury to the partner or child, and C1, includes a finding that such a person represents a credible threat to the physical safety of such intimate partner or child, or C2, by its terms explicitly prohibits the use, attempted use, or threatened use of physical force against such intimate partner or child that would reasonably be expected to cause bodily injury, to possess in or affecting commerce any firearm or ammunition. Rahimi moved to dismiss the indictment on the ground that Section 922G8 is unconstitutional, but he acknowledged that United States v. McGinnis foreclosed his argument. The district court denied Rahimi's motion, and he pled guilty. On appeal, Rahimi renewed his constitutional challenge to Section 922G8. Rahimi again acknowledged that his argument was foreclosed, and a prior panel of this court agreed. But after Bruin, the prior panel withdrew its opinion, ordered supplemental briefing, and ordered the clerk to expedite this case for oral argument before another panel of the court. Rahimi now contends that Bruin overrules our precedent and that under Bruin, Section 922G8 is unconstitutional. We agree on both points. Section 2. Under the rule of orderliness, one panel of the Fifth Circuit may not overturn another panel's decision absent an intervening change in the law, such as by a statutory amendment or the Supreme Court or our en banc court. The Supreme Court need not expressly overrule our precedent. Rather, a later panel must simply determine that a former panel's decision has fallen unequivocally out of step with some intervening change in the law. One situation in which this may naturally occur is where an intervening Supreme Court decision fundamentally changes the focus of the relevant analysis. That is the case here, as the government concedes. In Emerson, we held that the Second Amendment guarantees an individual right to keep and bear arms, the First Circuit expressly to do so. But we also concluded that Section 922G8 was constitutional as applied to the defendant there. Emerson first considered the scope of the Second Amendment right as historically understood, and then determined, presumably by applying some of the means-end scrutiny, sub silentio, that Section 922G8 was narrowly tailored to the goal of minimizing the threat of lawless violence. After D.C. v. Heller, 2008, U.S. Supreme Court decision, courts coalesced around a similar two-step inquiry for analyzing laws that might impact the Second Amendment. First, we asked whether the conduct at issue fell within the scope of the Second Amendment right. If the conduct fell outside the scope of the Second Amendment right, then the challenged law was constitutional. But if the conduct fell within the scope of the right, then we proceeded to the second step of analysis, which applied either intermediate or strict scrutiny. In McGinnis, this court upheld Section 922G8 using this two-step framework. The initial panel in this case did likewise, citing McGinnis. Enter Bruin. Expounding on Heller, the Supreme Court held that when the Second Amendment's plain text covers an individual's conduct, the Constitution presumptively protects the conduct. Bruin. In that context, the government bears the burden of justifying its regulation by demonstrating that it is consistent with the nation's historical tradition of firearm regulation. Put another way, the government must affirmatively prove that its firearms regulation is part of the historical tradition that delimits the outer bounds of the right to keep and bear arms. In the course of its explication, the court expressly repudiated the circuit court's means-end scrutiny, the second step embodied in the Emerson case and applied in McGinnis. To the extent that the court did not overtly overrule Emerson and McGinnis, it did not cite those cases, but discussed other circuits' similar precedent. Bruin clearly fundamentally changed our analysis of laws that implicate the Second Amendment, rendering our prior precedent obsolete. Section 3. Our review of Rahimi's facial challenge to Section 922G8 is de novo. First, the court addresses the government's argument that Rahimi is not among those citizens entitled to the Second Amendment's protections. Concluding he is, we then turn to whether Section 922G8 passes muster under Bruin's standard. According to the government, Heller and Bruin add a gloss on the Second Amendment that restricts its applicability to only law-abiding responsible citizens. Because Rahimi is neither responsible nor law-abiding, as evidenced by his conduct and by the domestic violence restraining order issued against him, he falls outside the ambit of the Second Amendment. Therefore, argues the government, Section 922G8 is constitutional as applied to Rahimi. The Second Amendment provides, simply enough, a well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. Heller explained that the words "the people" in the Second Amendment have been interpreted throughout the Constitution to unambiguously refer to all members of the political community, not an unspecified subset. Further, the people refer to a class of persons who are part of a national community or who have otherwise developed sufficient connection with this country to be considered part of that community. For those reasons, the Heller Court began its analysis with the strong presumption that the Second Amendment right is exercised individually and belongs to all Americans, and then confirmed that presumption. Heller's exposition of the people strongly indicates that Rahimi is included in the people and thus within the Second Amendment scope. To be sure, as the government argues, Heller and Bruin also refer to law-abiding responsible citizens in discussing the amendment's scope. And there is some debate over the extent to which the court's law-abiding qualifier constricts the Second Amendment's reach. As summarized by now Justice Barrett, one approach uses history and tradition to identify the scope of the right, and the other uses that same body of evidence to identify the scope of the legislature's power to take it away. The government's argument that Rahimi falls outside the community covered by the Second Amendment rests on the first approach, but it runs headlong into Heller and Bruin, which we read to espouse the second approach. That reading, in turn, leads us to conclude that in context, Heller simply uses law-abiding responsible citizen as shorthand in explaining that its holding, that the amendment codifies an individual right to keep and bear arms, should not be taken to cast doubt on long-standing prohibitions on the possession of firearms by felons and the mentally ill, or laws forbidding the carrying of firearms in sensitive places, such as schools and government buildings. In other words, Heller's reference to law-abiding responsible citizens meant to exclude from the court's discussion groups that have historically been stripped of their Second Amendment rights. That is, groups whose disarmament the founders presumptively tolerated or would have tolerated. From the record before us, Rahimi did not fall into any such group at the time he was charged with violating Section 922G8, so the strong presumption that he remained among the people protected by the Second Amendment holds. When he was charged, Rahimi was subject to an agreed domestic violence restraining order that was entered in a civil proceeding. That alone does not suffice to remove him from the political community within the amendment scope. And while he was suspected of other criminal conduct at the time, Rahimi was not a convicted felon or otherwise subject to another long-standing prohibition on the possession of firearms that would have excluded him. Indeed, the upshot of the government's argument is that the Second Amendment right can be readily divested, such that a person could be in one day and out the next. His rights would be stripped as a self-executing consequence of his new status. But this turns the typical way of conceptualizing constitutional rights on its head. And the government's argument reads the Supreme Court's law-abiding gloss so expansively that it risks swallowing the text of the amendment. Further, the government's proffered interpretation of law-abiding admits to no true limiting principle. Under the government's reading, Congress could remove unordinary or irresponsible or non-law-abiding people, however expediently defined, from the scope of the Second Amendment. Could speeders be stripped of the right to keep and bear arms? Political nonconformists? People who do not recycle or drive an electric vehicle? One easily gets the point. Neither Heller nor Bruin countenances such a malleable scope of the Second Amendment's protections. To the contrary, the Supreme Court has made clear that the Second Amendment right is exercised individually and belongs to all Americans. Rahimi, while hardly a model citizen, is nonetheless among the people entitled to the Second Amendment's guarantees, all other things being equal. Subsection B. Which brings us to the question of whether Rahimi's right to keep and bear arms may be constitutionally restricted by operation of Section 922G8. The parties dispute Rahimi's burden necessary to sustain his facial challenge to the statute. The government contends that Rahimi must establish that no set of circumstances exist under which the act would be valid. Rahimi contests that assertion, asserting during oral argument that the government's interpretation of Salerno has fallen out of favor, though he contends that in any event he has satisfied Salerno's standards. Bruin instructs how to proceed. The plaintiffs there levied a facial challenge to New York's public carry licensing regime. To evaluate the challenged law, the Supreme Court employed a historical analysis aimed at assessing whether modern firearms regulations are consistent with the Second Amendment's text and historical understanding. Construing Heller, the court flatly rejected any means-end scrutiny as part of this analysis, such that if a statute is inconsistent with the Second Amendment's text and historical understanding, then it falls under any circumstances. Bruin articulated two analytical steps. First, the court must determine whether the Second Amendment's plain text covers an individual's conduct. If so, then the Constitution presumptively protects that conduct. And the government must justify its regulation by demonstrating that it is consistent with the nation's historical tradition of firearm regulation. Only then may a court conclude that the individual's conduct falls outside the Second Amendment's unqualified command. To carry its burden, the government must point to historical precedent from before, during, and even after the founding that evinces a comparable tradition of regulation. We are not obliged to sift the historical materials for evidence to sustain 922G8. That is the government's burden. The government need not identify a historical twin, rather a well-established and representative historical analog. The Supreme Court distilled two metrics for courts to compare the government's proffered analogs against the challenged law: how the challenged law burdens the right to armed self-defense, and why the law burdens that right. Whether modern and historical regulations impose a comparable burden on the right of armed self-defense, and whether that burden is comparably justified, are central considerations when engaging in analogical inquiry. As to the degree of similarity required, analogical reasoning under the Second Amendment is neither a regulatory straitjacket nor a regulatory blank check. Courts should not uphold every modern law that remotely resembles a historical analog, because doing so risks endorsing outliers that our ancestors would never have accepted. On the other hand, even if a modern-day regulation is not a dead ringer for historical precursors, it still may be analogous enough to pass constitutional muster. The core question is whether the challenged law and proffered analog are relevantly similar. When the challenged regulation addresses a general societal problem that has persisted since the 18th century, the lack of a distinctly similar historical regulation addressing that problem is relevant evidence that the challenged regulation is inconsistent with the Second Amendment. Moreover, if earlier generations addressed the societal problem but did so through materially different means, that also could be evidence that a modern regulation is unconstitutional. Subsection C. Rahimi's possession of a pistol and a rifle easily falls within the purview of the Second Amendment. The amendment grants him the right to keep firearms, and possession is included within the meaning of keep. And it is undisputed that the types of firearms that Rahimi possessed are in common use, such that they fall within the scope of the amendment. The Second Amendment protects only the carrying of weapons that are those in common use at the time, as opposed to those that are highly unusual in society at large. Thus, Bruin's first step is met, and the Second Amendment presumptively protects Rahimi's right to keep the weapons officers discovered in his home. But Rahimi, like any other citizen, may have forfeited his Second Amendment rights if his conduct ran afoul of a lawful regulatory measure prohibiting the possession of firearms that is consistent with the historical tradition that delimits the outer bounds of the right to keep and bear arms. The question turns on whether Section 922G8 falls within that historical tradition or outside of it. To reiterate, the statute makes it unlawful for any person who is subject to a court order that was issued after a hearing of which such person received actual notice and in which such person had an opportunity to participate, restrain such person from harassing, stalking, or threatening an intimate partner of such person or child of such intimate partner or person, or engaging in other conduct that would place an intimate partner in reasonable fear of bodily injury to the partner or child, and C1 includes a finding that such person represents a credible threat to the physical safety of such intimate partner or child, or C2, by its terms, explicitly prohibits the use, attempted use, or threatened use of physical force against such intimate partner or child that would reasonably be expected to cause bodily injury, to possess in or affecting commerce any firearm or ammunition. Distilled to its essence, The provision operates to deprive an individual of his right to possess, keep, firearms once a court enters an order after notice in a hearing that restrains the individual from harassing, stalking, or threatening an intimate partner or the partner's child. The order can rest on a specific finding that the restrained individual poses a credible threat to an intimate partner or her child, or it may simply include a general prohibition on the use, attempted use, or threatened use of physical force reasonably expected to cause bodily injury. The covered individual forfeits his Second Amendment right for the duration of the court's order. This is so even when the individual has not been criminally convicted or accused of any offense, and when the underlying proceeding is merely civil in nature. These characteristics crystallize how and why Section 922G8 burdens a law-abiding citizen's right to armed self-defense. In particular, we focus on these key features of the statute. 1. Forfeiture of the right to possess weapons. 2. After a civil proceeding. 3. In which a court enters a protective order based on a finding of a credible threat to another specific person, or that includes a blanket prohibition on the use of and threatened use of physical force. 4. In order to protect that person from domestic gun abuse. The first three aspects get to how the statute accomplishes its goal. The fourth is the statute's goal, the why. To sustain Section 922G8's burden on Rahimi's Second Amendment right, the government bears the burden of proffering relevantly similar historical regulations that imposed a comparable burden on the right of armed self-defense that were also comparably justified. And when it comes to interpreting the Constitution, not all history is created equal. Constitutional rights are enshrined with the scope they were understood to have when the people adopted them. We thus afford greater weight to historical analogs more contemporaneous to the Second Amendment's ratification. The government offers potential historical analogs to Section 922G8 that fall generally into three categories. 1. English and American laws, and sundry unadopted proposals to modify the Second Amendment, providing for disarmament of dangerous people. 2. English and American going armed law. And 3. Colonial and early state surety insurance laws. We discuss in turn why each of these historical regulations falters as relevantly similar precursors to Section 922G8. Subsection 1. The government relies on laws of varying antiquity as evidence of its dangerousness analogs. We sketch these chronologically, mindful that greater weight attaches to laws nearer in time to the Second Amendment's ratification. Under the English Militia Act of 1662, officers of the Crown could seize all arms in the custody or possession of any person whom they judged dangerous to the peace of the kingdom. Citing scholarship, the government thus posits that by the time of American independence, England had established a well-practiced tradition of disarming dangerous persons, violent persons, and disaffected persons perceived as threatening to the crown. But the Militia Act's provenance demonstrates that it is not a forerunner of our nation's historical tradition of firearm regulations. Under Charles I, who reigned 1625 to 1649, the Crown and Parliament contested for control of the militia. After the resulting Civil War and Oliver Cromwell's seizure of power, the monarchy was restored in 1660 when Charles II took the throne. Charles II began using the militia to disarm his political opponents. The Militia Act of 1662 facilitated this disarmament, which escalated under the Catholic James II once he took the throne in 1685. After the Glorious Revolution, which enthroned Protestants William and Mary, the Declaration of Rights, codified as the 1689 English Bill of Rights, qualified the Militia Act by guaranteeing that the subjects, which are Protestants, may have arms for their defense suitable to their condition and as allowed by law. This right, which restricted the Militia Act's reach in order to prevent the kind of politically motivated disarmament pursued by Charles II and James II, has long been understood to be the predecessor to our Second Amendment. This understanding and the history behind it defeats any utility of the Militia Act of 1662 as a historical analog for Section 922G8. The government next points to laws in several colonies and states that disarmed classes of people considered to be dangerous, specifically including those unwilling to take an oath of allegiance, slaves, and Native Americans. These laws disarmed people thought to pose a threat to the security of the state due to their perceived lack of loyalty or societal status. While public safety was a concern, most disarmament efforts were meant to prevent armed rebellion. The early Americans adopted much of that tradition in the colonies. But we question at a threshold level whether colonial and state laws disarming categories of disloyal or unacceptable people present tenable analogs to Section 922G8. Laws that disarmed slaves, Native Americans, and disloyal people may well have been targeted at groups excluded from the political community, written out of the people altogether, as much as they were about curtailing violence or ensuring the security of the state. Their utility as historical analogs is therefore dubious at best. In any event, these laws fail on substance as analogs to Section 922G8 because out of the gate, why they disarmed people was different. The purpose of laws disarming disloyal or unacceptable groups was ostensibly the preservation of political and social order, not the protection of an identified person from the threat of domestic gun abuse. Thus, laws disarming dangerous classes of people are not relevantly similar to Section 922G8, such that they can serve as historical analogs. Finally, the government offers two proposals that emerged in state ratification conventions considering the proposed Constitution. A minority of Pennsylvania's convention authored a report in which they contended that citizens have a right to bear arms unless for crimes committed or real danger of public injury. And at the Massachusetts convention, Samuel Adams proposed a qualifier to the Second Amendment that limited the scope of the right to peaceable citizens. But these proposed amendments are not reflective of the nation's early understanding of the scope of the Second Amendment right. While they were influential proposals, neither became part of the Second Amendment as ratified. Thus, the proposals might somewhat illuminate the scope of firearms rights at the time of ratification, but they cannot counter the Second Amendment's text or serve as an analog for Section 922G8 because, inter alia, they were not enacted. Subsection 2. The government also relies on the ancient criminal offense of going armed to terrify the king's subjects. This common law offense persisted in America and was in some cases codified. The government offers 4 exemplars codified in the Massachusetts Bay Colony, the state of Virginia, and the colonies of New Hampshire and North Carolina. The Massachusetts law provided that every justice of the peace may cause to be stayed and arrested all affrayers, rioters, disturbers, or breakers of the peace, and such as shall ride or go armed offensively, and upon view of such justice or justice's confession of the party or other legal conviction of any such offense, shall commit the offender to prison and seize and take away his armor or weapons. Similarly, the New Hampshire statute authorized justices of the peace, upon view of such justice, confession of the party, or legal proof of any such offense, to cause the offender's arms or weapons to be taken away. Virginia's law differed slightly. No man shall go or ride armed by night or by day in fairs or markets or in other places in terror of the country, upon pain of being arrested and committed to prison by any justice on his view or proof of others, there to a time for so long as a jury to be sworn for that purpose by the said justice shall direct, and in like manner to forfeit his armor to the Commonwealth. North Carolina's colonial law was contained within its constable's oath, which required constables to arrest all such persons as in your sight shall ride or go armed offensively, or shall commit or make any riot, affray, or other breach of his majesty's peace. While similarly aimed at curbing going armed offensively, the North Carolina law did not provide for forfeiture. These proffered analogs fall short for several reasons. An overarching one is that it is doubtful these going armed laws are reflective of our nation's historical tradition of firearm regulation, at least the forfeiture of firearms. North Carolina's law did not provide for forfeiture, so it quickly falls out of the mix. And fairly early on, Massachusetts and Virginia dropped forfeiture as a penalty, going the way of North Carolina, and thereby undercutting the government's reliance on those laws. Indeed, Massachusetts amended its law to remove the forfeiture provision in 1795, just 4 years after the ratification of the Second Amendment. Virginia had done so by 1847, shortly before the Commonwealth recodified its laws in 1849. It is unclear how long New Hampshire's going armed law preserved its forfeiture provision, but assuming, arguendo, it persisted longer than the others, one outlier is not enough to show a tradition of public carry regulation. And on substance, the early going armed laws that led to weapons forfeiture are not relevantly similar to Section 922G8. First, those laws only disarmed an offender after criminal proceedings and conviction. By contrast, 922G8 disarms people who have merely been civilly adjudicated to be a threat to another person, or who are simply governed by a civil order that by its terms explicitly prohibits the use, attempted use, or threatened use of physical force, whether or not there is a credible threat to the physical safety of anyone else. Rahimi's domestic violence restraining order satisfied both conditions, but it bears emphasis that the order at issue here was entered by agreement in a civil proceeding after Rahimi apparently waived hearing. The order states no formal hearing was held and no record was created, and without counsel or other safeguards that would be afforded to him in the criminal context. These distinctions alone defeat the going armed laws as useful analogs for Section 922G8. Moreover, the going armed laws, like the dangerousness laws discussed above, appear to have been aimed at curbing terroristic or riotous behavior. That is, disarming those who have been adjudicated to be a threat to society generally, rather than to identified individuals. And Section 922G8 works to disarm not only individuals who are threats to other individuals, but also every party to a domestic proceeding. Think divorce court, who, with no history of violence whatever, becomes subject to a domestic restraining order that contains boilerplate language that tracks Section 922G8C2. In other words, where going armed laws were tied to violent or riotous conduct and threats to society, Section 922G8 implicates a much wider swath of conduct, not inherently dependent on any actual violence or threat. Thus, these going armed laws are not viable historical analogs for Section 922G8. Lastly, the government points to historical surety, insurance laws. At common law, an individual who could show that he had just cause to fear that another would injure him or destroy his property could demand surety of the peace against such person. The surety was intended merely for prevention, without any crime actually committed by the party, but arising only from probable suspicion that some crime was intended or likely to happen. If the party of whom surety was demanded refused to pay surety, he would be forbidden from carrying a weapon in public, absent special need. Many jurisdictions codified this tradition, either before ratification of the Bill of Rights or in early decades thereafter. The surety laws come closer to being relevantly similar to Section 922G8 than the dangerousness and going arms laws discussed above. First, they are more clearly a part of our tradition of firearm regulation, and they were comparably justified, in that they were meant to protect an identified person who sought surety from the risk of harm posed by another identified individual who had to post surety to carry arms. Put simply, the why behind historical surety laws analogously aligns with that why underlying Section 922G8. Aspects of how the surety laws worked resemble certain of the mechanics of Section 922G8 as well. The surety laws required only a civil proceeding, not a criminal conviction. The credible threat finding required to trigger Section 922G8C1's prohibition on possession of weapons echoes the showing that was required to justify posting of surety to avoid forfeiture. But that is where the analogy breaks down. As the government acknowledges, historical surety laws did not prohibit public carry, much less possession of weapon, so long as the offender posted surety. Where the surety laws imposed a conditional partial restriction on the Second Amendment right, Section 922G8 works in absolute deprivation of the right, not only publicly to carry, but to possess any firearm upon entry of a sufficient protective order. And as discussed above, Section 922G8C2 works that deprivation based on an order that prohibits the use, attempted use, or threatened use of physical force, whether there is just cause to fear any harm or not. At bottom, the historical surety laws do not impose a comparable burden on the right of armed self-defense, as Section 922G8. The government fails to demonstrate that Section 922G8's restriction of the Second Amendment right fits within our nation's historical tradition of firearm regulation. The government's proffered analogs falter under one or both of the metrics the Supreme Court articulated in Bruin as the baseline for measuring relevantly similar analogs. How and why the regulations burden a law-abiding citizen's right to armed self-defense. As a result, Section 922G8 falls outside the class of firearm regulations countenanced by the Second Amendment. Doubtless, 18 U.S.C. Section 922G8 embodies salutary policy goals meant to protect vulnerable people in our society. Weighing those policy goals' merits through the sort of means and scrutiny our prior precedent indulged, we previously concluded that the societal benefits of Section 922G8 outweighed its burden on Rahimi's Second Amendment rights. But Bruin forecloses any such analysis in favor of a historical, analogical inquiry into the scope of the allowable burden on the Second Amendment right. Through that lens, we conclude that Section 922G8's ban on possession of firearms is an outlier that our ancestors would never have accepted. Therefore, the statute is unconstitutional, and Rahimi's conviction under that statute must be vacated. James C. Ho, Circuit Judge, concurring. The right to keep and bear arms has long been recognized as a fundamental civil right. Blackstone saw it as an essential component of the natural right to self-preservation and defense. And the Supreme Court has repeatedly analogized the Second Amendment to other constitutional rights guaranteed to every American. But lower courts have routinely ignored these principles, treating the Second Amendment as a second-class right. So the Supreme Court has now commanded lower courts to be more forceful guardians of the right to keep and bear arms by establishing a new framework for lower courts to apply under the Second Amendment. When the Second Amendment's plain text covers an individual's conduct, the Constitution presumptively protects that conduct. The government must then justify its regulation by demonstrating that it is consistent with the nation's historical tradition of firearm regulation. This historical inquiry that courts must conduct will often involve reasoning by analogy, a commonplace task for any lawyer or judge. Like all analogical reasoning, determining whether a historical regulation is a proper analog for a distinctly modern firearm regulation requires a determination of whether the two regulations are relevantly similar. This framework is neither a regulatory straitjacket nor a regulatory blank check. It requires the government to identify a well-established and representative historical analog, not a historical twin. Our court's decision today dutifully applies Bruin, and I join it in full. I write separately to explain how respect for the Second Amendment is entirely compatible with respect for our profound societal interest in protecting citizens from violent criminals. Our founders firmly believed in both the fundamental right to keep and bear arms and the fundamental role of government in combating violent crime. The right to keep and bear arms has controversial public safety implications, but it's hardly the only constitutional right that does. To the contrary, all of the constitutional provisions that impose restrictions on law enforcement and on the prosecution of crimes fall into the same category. So any legal framework that involves any of these constitutional provisions can have significant and controversial public safety consequences. A framework that underprotects a right unduly deprives citizens of liberty, but a framework that overprotects a right unduly deprives citizens of competing interests like public safety. Take, for example, the exclusionary rule under Mapp v. Ohio, 1961 U.S. Supreme Court decision. Since its inception, the rule has been sharply criticized for overprotecting the accused and releasing dangerous criminals into our neighborhoods. It's often said that nothing in the Constitution requires the criminal to go free because the constable has blundered. The exclusionary rule generates substantial social cost by setting the guilty free and the dangerous at large. The same can be said about Miranda v. Arizona, the U.S. Supreme Court, 1966. The Supreme Court has repeatedly referred to the Miranda warnings as prophylactic and not themselves rights protected by the Constitution. What's more, in some unknown number of cases, the court's rule will return a killer, a rapist, or other criminal to the streets and to the environment which produced him, to repeat his crime whenever it pleases him. So it's easy to see why decisions like Mapp and Miranda have been criticized for overprotecting constitutional rights and harming public safety. But there's a big difference between the first criticism and the second, at least as far as the judiciary is concerned. It's our duty as judges to interpret the Constitution based on the text and original understanding of the relevant provision, not on public policy considerations, or worse, fear of public opprobrium or criticism from the political branches. And that's precisely the problem here. Members of the Supreme Court have repeatedly criticized lower courts for disfavoring the Second Amendment. The Supreme Court has now responded by setting forth a new legal framework in Bruin. It is incumbent on lower courts to implement Bruin in good faith and to the best of our ability. Bruin calls on us to examine our nation's history and traditions to determine the meaning and scope of the Second Amendment. It's hardly the first time that the Supreme Court has looked to history and tradition to interpret constitutional provisions, and it surely won't be the last. Section 2 of the concurrence. Those who commit violence, including domestic violence, shouldn't just be disarmed. They should be detained, prosecuted, convicted, and incarcerated. And that's exactly why we have a criminal justice system, to punish criminals and disable them from engaging in further crimes. The Constitution presumes the existence of a criminal justice system. That system allows the government to deny convicted criminals a wide range of liberties that it could not deny to innocent law-abiding citizens. For example, the government cannot deprive innocent citizens of their liberty of movement, but it can certainly arrest and incarcerate violent criminals. Arrest and incarceration naturally entail the loss of a wide range of liberties, including the loss of access to weapons. The Supreme Court has also made clear that our nation's history and traditions include long-standing prohibitions on the possession of firearms by felons, and that such measures are presumptively lawful. So the government can presumably disarm dangerous convicted felons, whether they're incarcerated or not, without violating the Second Amendment. The Second Amendment is not a second-class right. It is not subject to an entirely different body of rules than the other Bill of Rights guarantees. That principle guides us here. The government can impose various restrictions on the rights of dangerous convicted felons, consistent with our nation's history and traditions, and that includes the right to keep and bear arms. Section 3. The power to incarcerate violent criminals is not just constitutionally permissible, it's imperative to protecting victims. After all, anyone who's willing to break the law when it comes to domestic violence is presumably willing to break the law when it comes to guns as well. The only way to protect the victim may be to detain, as well as to disarm, the violent criminal. For example, the government can detain and disarm not just after conviction, but also before trial. Pre-trial detention is presumed by the excessive bail clause and the speedy trial clause, and it plays a significant role in protecting citizens from violence, including domestic violence. In addition, the government can detain and disarm based not just on acts of violence, but criminal threats of violence as well. After all, to the victim, such actions are not only life-threatening, they're life-altering, even if they don't eventually result in violence. Section 4. 18 U.S.C. Section 922G8 disarms individuals based on civil protective orders, not criminal proceedings. As the court today explains, there is no analogous historic tradition sufficient to support 922G8 under Bruin. Moreover, there are additional reasons why disarmament based on civil protective orders should give us pause. Scholars and judges have expressed alarm that civil protective orders are too often misused as a tactical device in divorce proceedings and issued without any actual threat of danger. That makes it difficult to justify Section 922G8 as a measure to disarm dangerous individuals. Subsection 4A. Many divorce lawyers routinely recommend pursuit of civil protection orders for clients in divorce proceedings as a tactical leverage device. That's because civil protective orders can help a party in a divorce proceeding to secure favorable rulings on critical issues such as marital and child support, exclusion from marital residence, and property disposition. Protective orders can also be a powerful strategic tool in custody disputes. That makes civil protective orders a tempting target for abuse. Judges have expressed concern with the serious policy implications of permitting allegations of domestic abuse to be used in divorce proceedings. And for good reason. Not all parties to divorce are above using protective orders not for their intended purpose, but solely to gain advantage in a dissolution. Anyone who is willing to commit perjury can spend months or even years planning to file a domestic violence complaint at an opportune moment in order to gain the upper hand in a divorce proceeding. So a plaintiff willing to exaggerate past incidents or even commit perjury can have access to a responsive support group, a sympathetic court, and a litany of immediate relief. Moreover, these concerns are exacerbated by the fact that judges are too often ill-equipped to prevent abuse. Family court judges may face enormous pressure to grant civil protective orders and no incentives to deny them. For example, family court judges may receive mandatory training in which they're warned about the unfavorable publicity that could result if they deny requests for civil protective orders. As one judge has noted, a newspaper headline can be death to a municipal court judge's career. So the prospect of an unfavorable newspaper headline is a frightening one. To quote another judge, "Your job is not to become concerned about all the constitutional rights of the defendant you're violating as you grant a restraining order. Throw him out on the street. Give him the clothes on his back and tell him, see you around." Yet another judge said, "If there is any doubt in your mind about what to do, you should issue the restraining order." As a result, restraining orders are granted to virtually all who apply. So there's a tremendous risk that courts will enter protective orders automatically, despite the absence of any real threat of danger. In one case, for example, a family court judge granted a restraining order on the ground that the husband told his wife that he did not love her and was no longer attracted to her. There was no prior history of domestic violence, yet the judge issued the order anyway. Another judge issued a restraining order against David Letterman on the ground that his presence on television harassed the plaintiff. Subsection 4B. Moreover, the consequences of disarming citizens under Section 922G8 may be especially perverse, considering the common practice of mutual protective orders. In any domestic violence dispute, a judge may see no downside in forbidding both parties from harming one another. A judge may think that mutual restraining orders are not substantially different from regular restraining orders. After all, the goal is to keep the parties away from one another so that violence will not continue. Judges may also feel that issuing a mutual restraining order saves time because they do not have to hear testimony and make a finding regarding which party is a primary aggressor or even that one party has committed domestic violence. But these judicial assessments have often led to the issuance of unmerited mutual restraining orders, namely in situations where one party is the abuser and the other party is a victim. As a result, both parties are restrained even if only one is an abuser. The net result of all this is profoundly perverse because it means that 922G8 effectively disarms victims of domestic violence. What's worse, victims of domestic violence may even be put in greater danger than before. Abusers may know or assume that their victims are law-abiding citizens who will comply with their legal obligations, not to arm themselves in self-defense due to Section 922G8. Abusers might even remind their victims of the existence of Section 922G8 and the entry of a mutual protective order to taunt and subdue their victims. Meanwhile, the abusers are criminals who have already demonstrated that they have zero propensity to obey the dictates of criminal statutes. As a result, Section 922G8 effectively empowers and enables abusers by guaranteeing that their victims will be unable to fight back. We must protect citizens against domestic violence, and we can do so without offending the Second Amendment framework set forth in Bruin. Those who commit or criminally threaten domestic violence have already demonstrated an utter lack of respect for the rights of others and the rule of law. So merely enacting laws that tell them to disarm is a woefully inadequate solution. Abusers must be detained, prosecuted, and incarcerated. And that's what the criminal justice system is for. I concur. And that's it, folks. The Fifth Circuit decision, U.S. v. Rahimi, that's now going to the Supreme Court to be argued there, with many amici being filed by interested groups, including Friends of Law Self-Defense. I'll be reading at least one of those to you later this week. Remember, folks, if you carry a gun so you're hard to kill, that's why I carry a gun. That's why I carry a knife. That's why I carry pepper spray. It's why I practice Brazilian Jiu-Jitsu. Then you also owe it to yourself and your family to make sure you know the law so you're hard to convict as well. Until next time, I remain Attorney Andrew Branker for Law of Self-Defense. Stay safe.